America's center of power changed, and with it, the dynamics of the political landscape. The consequences will reverberate locally, in Florida, on Capitol Hill, and on the global stage. Voters demanded change on the issues that mattered most: the economy, immigration, and social issues. Now, News4JAX goes beyond the headlines with political analysts who provide unique context and perspective. Experts focused on the issues making headlines. This is Politics and Power.
It is hardly arguable President Trump is very willing to test legal boundaries. The conservative majority on the Supreme Court seems to be very willing and giving him ample leeway. Yes, there are legal fights upon which the president is certainly not focused. Where is his focus? It is on politics. It is on how far he can stretch both the legal and political boundaries. And the real test on both is yet to come. Welcome to Politics and Power. I'm Bruce Hamilton. My guest this week, News4JAX political analyst and head of the Jacksonville University Public Policy Institute, Rick Mullaney, and Jacksonville University law professor Nathan Richardson. Gentlemen, welcome. Good to have you here.
Thanks so much for having me.
Great to be with you, Bruce.
So let's start with a bit of history. If you examine several major rulings handed down by the six-member conservative majority in the Supreme Court, it would seem there is little willingness to mitigate President Trump's power. The Supreme Court recently gave President Trump a partial victory on one of the most far-reaching executive orders. Nathan, let's start with the 6-3 vote. The Supreme Court ruling that district courts don't have the power to issue nationwide injunctions, including ones to stop President Trump's executive order banning birthright citizenship. It was explained by Justice Amy Coney Barrett this way. Federal courts do not exercise general oversight of the executive branch. They resolve cases and controversies. So what's Justice Barrett saying here, and did she give Mr. Trump a lot of legal leeway?
If you had asked me this question about the position of the courts vis-a-vis the Trump administration 6 weeks ago, we might have been having a different conversation. If you remember then, there was the Kilmar-Abrego-Garcia case where there had been some setbacks for the administration. Basically, the courts ordered him brought back to the United States, and it looked like there were going to be checks from the courts in general and the Supreme Court in particular on Trump's power. I think it's fair to say that seems a little less likely now, although maybe you could tell a story through the cases. The particular case that you reference on nationwide injunctions, or maybe better called universal injunctions because they apply to all parties, Amy Coney Barrett's right in the quote that you suggest, or that you brought up here, in that the role of the courts is to resolve disputes between individual parties. Does that mean sometimes that the implications of the result of that can have broad-reaching implications? Yes. Commentators from both parties have questioned for some time about whether one district court should be able to rule essentially for the whole country. But sometimes the equities have been balanced. Sometimes the judges have determined that makes sense. It is a little bit surprising, I would say, not that the Supreme Court put a stop, or at least put a limited halt to that practice. And we can talk more about the details in a minute. But that they did so in this case. Why do this now when there had been similar questions about universal injunctions being issued to actions under the Biden administration or the Obama administration or during Trump's first term for that matter? Why do it now? Why do it on an issue like birthright citizenship where, and we may get into this, the legal outcome is frankly quite clear. The Constitution is fairly clear here. This is a fairly limited decision, but it does represent a substantial setback to those who want to use the courts to stop administration policy. Can they still get final resolution of their dispute? Yes, but it makes that path a lot harder than it would be otherwise.
So, Rick, why do it now?
Well, there's been an outcry, but it happened both in the Biden administration and it's happened now on universal injunctions. And I do think it's important to separate the merits of the case versus what this means. This does not mean Trump wins. And in fact, I'd suggest there are a number of cases that are going to go before the U.S. Supreme Court in which I think he's fighting an uphill battle. On this one, for example, on the merits, when it gets to the Supreme Court, I expect him to lose. His executive orders on major law firms and the limitations on those law firms, he's lost in the federal district courts. If that gets to the Supreme Court, I expect him to lose. Even with Harvard, and it was quite interesting this week, he's already criticizing the judge prior to the ruling. I think that's an uphill battle for him, and even on tariffs. So here, I think what the court was really doing with the universal injunctions was trying to get the court, in their view, to stay in its lane, to stay away from the imperial judiciary as opposed to the imperial presidency. And already with a class action lawsuit, it's already been reimposed. And so, as Nathan says, I'm not so sure of the timing, but I wouldn't overread this. too much, because I do think on the merits, on many cases, the Trump administration may not get the rulings that they want out of this U.S. Supreme Court, even with that 6-3 majority.
Yeah, let's take the case of Harvard, because basically the judge came back and said, you know, I don't think you've proven your case. You know, you're saying it's about anti-Semitism. It's not. You know, we're talking about funding for cancer research and things, and you talk about anti-Semitism. You've got the president of Harvard who happens to be Jewish. I think the case here is really about academic freedom.
I think, without going too deep into that case, where I haven't read the judge's most recent opinion, like I think Rick is right on one level that this is a preliminary decision. The same thing is true in the Harvard case. Harvard case is to put a finer point on it, that is a dispute between two parties, the government and Harvard, and the courts can resolve that dispute. When you have a dispute between the government and basically everyone born in the United States to foreign parents, who the administration is attempting to conclude is no longer eligible for citizenship. That's one against many, and it's much harder for the courts to resolve those issues. One of the expedients available to the court is a nationwide injunction, but there are others. You can do a class action, you know, something you see a lot in private litigation. The Supreme Court left that door open. There's other kinds of statutory methods. The Supreme Court even left the door open for states to directly challenge action and get nationwide injunctions. So there's a lot of doors possible where, and I agree with Rick here, the administration is likely not only to ultimately lose on this birthright citizenship question, but when it does, have it apply basically universally. Now, that doesn't mean that the process won't take a lot longer than it would otherwise, or that there might be individual people who are denied citizenship because that process will take longer.
Okay, that said, what the Trump administration really wanted was a ruling that gave them a win on birthright citizenship. Yes. And it did not end birthright citizenship or close the door on it. The court's decision focused on limiting the power of federal judges to issue nationwide injunctions, specifically in the context of President Trump's executive order regarding birthright citizenship. It didn't address the constitutionality of birthright citizenship itself, which is still protected by the 14th Amendment.
That's right.
That's exactly correct.
So, it didn't give the president what it wanted. And like you said, they can still go through the route of, a class action suit or things like that, or through the lower courts.
That's right. It didn't change the law, the substantive law, and what does the 14th Amendment mean, who becomes a citizen. But it means there's a difference between what the law is as written and then what actually happens in reality. And until we have a final resolution of this case, at least in some states that are compliant with the president's order, he is going to effectively deny citizenship to some people. Are they going to be able to go back and get it later after this case is resolved? And as Rick and I think the president ends up losing, I hope so. But some of them by that time may have been deported or may have left the country or may not have access to legal remedies or may not have the money to pursue that legal action. And so thereby may be ultimately denied citizenship. And you can see this in the Department of Education case as well. Sometimes if a court doesn't solve the problem immediately or doesn't preserve the status quo immediately, then regardless of what the outcome of the final suit is, it can be a fait accompli. The result that the executive wants can be achieved.
And in doing that, is the president, Rick, overstepping his bounds?
Well, he's pushing the limit. And in fact, that raises something that Nathan said earlier that I think is really important. And that is that there's some litigation between two parties that the courts are positioned to resolve. For example, Harvard and the administration, and also those law firms in the administration. One of the problems for higher education and for those law firms, as this goes to your question about overstepping your bounds, is they have to make a decision, is winning the litigation a victory? Because in that, they have a business to run. It's a higher ed institution. They have a law firm to run. And you saw major law firms on Wall Street, look at this problem and say, we could win the litigation and we could go out of business. They made a decision to resolve it, to settle. Other law firms made a very different decision, and they've been successful in the federal courts, and we'll see how that plays out from a business standpoint. And then you have the same thing, again, with these litigants with Harvard. Some of these others, such as tariffs, such as birthright citizenship, are much broader than the individual parties. But in the first 6 months of the Trump administration, certainly what we have seen is the president's willingness to push the limits of executive power, particularly on these executive orders, in higher education, in law firms, in tariffs, on immigration, on deportation, and in cutting the federal government. And you're looking to the courts to provide those limitations, and the court is saying, let this play out in the court system. And even in those cuts, they weren't ruling on the merits. They are saying, as the litigation continues, Donald Trump can continue with what he's doing in the executive branch. But in answer to your question, he is certainly pushing the limits of executive power.
And certainly nothing is black and white. So before we discuss other specific cases, let's get into some more history here. The Constitution outlines the powers of Congress and the president in Articles 1 and 2. It formally gives Congress the power of the purse and requires the president to take care care of the laws to be faithfully executed. Statutes dictate how agencies operate, how appointments are made, and how funds must be spent.
The Supreme Court may
Courts
have wide-ranging
interpret and enforce these rules. The founding fathers of this country had concerns with unchecked executive powers. That's why the legal constraints were placed. And look to the Declaration of Independence. Was that not a direct rebuke of royal overreach, or to be applied, in this case, executive overreach?
I think that's a fair summary of the core of the founding documents. We have a tripartite system of government. It's not perfect. It has a lot of flaws in it that we've seen. But if there's one thread that you can pull out of it, is to avoid the concentration of power because of the effects that has on freedom, on liberty, on success as a country. That's why we have three branches. One branch that we haven't talked about very much here is Congress. Like, we have been talking about, are the courts able to check the executive here? And we've talked about some ways in which that's maybe true to a limited extent. We could talk more about that. Congress seems to be asleep at the wheel here in terms of its role in enforcing its own statutes and ensuring that the executive takes care to faithfully execute the laws. They are, and it's not a coincidence that both houses of Congress are controlled by the president's own party. But this level of compliance with the executive, this level of inaction, of simply going along with what he and his administration seem to want, is historically very unusual, perhaps unprecedented.
Oh, and most of those members of Congress right now are more worried about their own futures than they are about what's happening in America.
Sure, that's that's normal, but that has not always meant do exactly what the president wants. That is not the role of Congress that the framers intended.
No, and this isn't something that's new. Constraints and the law alone has never been enough to prevent presidents from abusing their power. Law's force depends on political will. Presidents often follow the law, not simply because they must, but to avoid backlash from Congress, the media, or the public. And, we've seen it in the past.
Mm-hmm. Talking about it, like when you say that the power to determine what the law is in part comes from politics, that sounds sometimes cynical, but underneath it is an actual hopeful concept, which is that the ultimate arbiter of what the Constitution means is the people. Who are we going to vote for? Who are we going to support? Who are we willing to go out and protest? Who are we willing to speak loudly in our communities is doing something that we can or that we won't accept? That is ultimate. Every branch has a responsibility, not just the courts, to interpret the Constitution. And the people have one, too. That's the price of living in a republic, and especially one of divided powers like we have.
Yeah, and you're actually getting ahead of me here, because at the end of the program, I'm going to talk about the power of the people. And people talk about being cynical, don't think that they do have any power these days, but I think they do, and we will get to that topic. There are at least 14 other emergency appeals that Trump brought to the High Court. The justices granted his request, I think it was on 12 occasions, at least partially. The conservative majority gave the green light to the Trump administration's mass layoffs of federal workers. The impact of this may be far-reaching and transform the federal government. Some Democratic members of Congress and advocacy groups argue that the administration is acting without the proper congressional approval and that these actions will harm vital government services, have a negative impact. Justice Ketanji Brown Jackson, in a dissenting opinion, emphasized that the large-scale reorganizations require partnership with Congress and should not be undertaken in disregard of congressional mandates. Is the president here overstepping his bounds?
Well, Democrats think so, but let me back up a little bit and put this in a little bit of context as to what's happened here. And by the way, Justice Brown, she gave a dissenting opinion, but in that case—
major dissent.
Yes, but remember this, Justice Sotomayor and Kagan were on the other side. They were in the majority, and what they were saying, by the way, is that this isn't being decided on the merits. And in fact, as Justice Sotomayor said, this isn't about if they started to violate applicable law, I'd be in a different place. This is more, given the status of the litigation, they're going to allow him to continue with these layoffs. But let's put it in context. When he first came to office, the federal bureaucracy and government employment had grown dramatically. Federal employment was about 2.3 to 2.4 million federal employees when he took office. And that doesn't even include the post office. When you include them, it's another 600,000, 3 million employees. Of that 2.4 million, you've seen a reduction in force of about 275,000. That's a lot. That's about 12%. The vast majority have come from resignations, retirements, taking payouts, whatever that might be, with some layoffs. So one person's overstepping or dismantling, as you might say, is another person's right-sizing. And although you would have to say that Musk was certainly unpopular, he did tap into this notion of we need to get control of a growing federal government, of expenditures, and the size of government. And it's one reason why he was so critical of the big, beautiful bill, because it wasn't consistent with his work. And so as this plays out, this is another example in which on the merits we'll have to see where this turns out, because he could lose on the merits in the end, but the court was very clear that they were going to allow Trump to do this while the litigation continues, and that it was not really.
Not to step on you here, but in doing so, are they just trimming the fat, Nathan, do you think? Or are they dismantling portions of government that are going to come at a cost to Americans, where people who need health care aren't going to be able to get it, people who rely on Medicaid aren't going to, 70 million people aren't going to be able to get it?
There has historically been, when the government operates, when the executive operates, what's called a presumption of regularity, that they are doing things the way that they have generally been done. That doesn't mean you can't do a new policy, but you are following the rules. And then when the government comes into court, the courts have given that presumption of regularity. And that's the reason why, as Rick suggested, generally when the government does something and somebody's unhappy about it and sues, the government gets to keep doing the thing. Otherwise, government would grind to a halt every time somebody unhappy with what government was doing. So in that sense, this is a normal decision, that it's not a final decision. We're just going to let the government keep doing what they're doing. But this administration is on the record, in press releases, in the campaign, saying they wanted to dismantle the Department of Education. So when they fire thousands of workers, but then claim it's just a standard reduction in force, Americans don't believe that. And the court shouldn't believe that either. So this, in this case, Justice Kagan is correct that in form, this is a normal case. We're letting the government proceed until we reach the final decision. But step back, just take 1 or 2 steps back, not a lot, and look at what the government's actually saying. We want to dismantle the Department of Education. And then you can see that this is not, that the presumption of regularity should not hold, that this is not a simple reduction in force. There may be others that are more along the lines Rick described elsewhere in the government, but this administration says they want to dismantle the Department of Education. Believe them.
If Ed, I could agree with that, because by the way, if it's a dismantling, that crosses the line that we're talking about. That gets into the Article I powers. That gets into congressional authority, both in appropriations and the structure that they've set up. It's one thing to have a reorganization. They even talked about that in the opinion, which they said they're passing no judgment on what the reorganization plan is, or a reduction in force. That's one thing. Dismantling is another. Doing away with is another, because that was set up by legislation, by statute, and appropriated by statute. So this is going to play out over time. In the end, however, as we saw with those tragic floods in Texas, and as we see in other areas, people don't mind if you want to cut spending or reduction in force, as long as you provide the same services. But when questions rise, did you respond adequately? Are you providing the services do you need? Are people in danger? Big cuts in the Department of Defense, for example. That's one of the biggest areas of employment, over 60,000 there in a reduction in force. So we're going to have to see how this plays out in terms of the delivery of services and whether or not these reductions, how it impacts that.
Or when you say, we're going to pass these services on to the states, when the states don't have the wherewithal to, bear that burden. Let's move on to immigration. The court allowed deportation of non-citizens to third countries with little due process. This is a contentious issue with legal challenges ongoing. Main question here, are due process rights fundamental even for non-citizens, Nathan?
The short answer is yes. And let me give you 3 reasons. One is a legal reason. If you look at the rights of due process, indeed almost every important right in the Constitution, it is guaranteed to all persons, not to citizens, but to all persons. That's something we resolved in the case of the 14th Amendment, because we had a debate for the first third of this, the history of this country, about who counts as a person. That was resolved legally in the 14th Amendment, but it was resolved at places like Antietam and Gettysburg. So we had that debate. That debate was resolved there. It's in a moral sense, I think most Americans would agree that basic rights like due process are human rights, and they apply to most people. But even if you don't agree with that, most fundamentally, if you as a citizen are guaranteed due process rights, but non-citizens are not, then you effectively don't have due process rights. Because the first thing the government can say is, we don't think you're a citizen. How could you possibly prove that you're a citizen? You need some process to do that. So you must, in order to protect due process rights for citizens, due process rights must also be available to non-citizens. A basic right to appear in court, advance your claims, defend yourself against a claim that the government is making that you don't have those rights.
And Rick, it's become quite obvious that the Trump administration, people like Steve Homan, Stephen Miller, and others, aren't listening to the American public, because the the latest polls that come out show that the majority of Americans right now are not in favor with the way the administration is going about dealing with the whole immigration crisis.
Well, I do think there's a danger here in the Trump administration overplaying its hand, because they've had some great success and they've had public support, number one, in securing the border. And there has been great support for what they've done in securing the border during the first 6 months of the administration. That is at the top of the list for him in pointing to success. Second, when it comes to deportation and the deportation of those who've committed crimes, or for where there's an order by the court deporting them, there's great public support for that too. At the other end, the other end of the spectrum is dreamers, for example, and the public has great support for those dreamers, the children of illegal immigrants. One of the challenges, and we saw it in Los Angeles, however, is when you begin to deport those who aren't in none of those categories. They're not criminals, but they're not dreamers, but they've been here for many years and they haven't broken a law and they're employed, and you begin to deport them because they're illegal or they're technically something has happened, that's where the public begins to question. And even Trump himself has begun to recognize some of the nuances here in terms of the economy, and that it's not monolithic. They're not all in one category, that there are some differences here. So I do think that Donald Trump does enjoy support on this overall. It has been his signature issue since 2015. If you look over the last decade and you said, what is the one issue that Donald Trump in particular has run on, it has been this issue. And he's playing it hard and he's pushing it hard, and he still has support, but I do think there's a danger in overplaying his hand, and I think he recognizes that somewhat.
He may recognize it somewhat. I'm not so sure that Tom Homan and Stephen Miller do.
If I can add slightly to that, I agree with everything Rick said, except for the small point that he suggested that as far as the Trump administration wants to go is to take people that fit into these categories of dreamers and perhaps deport them. And of course, there's not great support for that. The Trump administration clearly wants to go farther. We talked about birthright citizenship. It wants to deny citizenship and ultimately deport people who were born in this country. Vice President Vance gave a speech at Claremont in California recently where he effectively advanced a blood and soil version of nationalism, where he said if you don't have ancestors that fought in the Civil War, you have less of a claim to be American. Down that path lies deporting not just dreamers, but a large proportion of people that the vast majority of Americans would call their friends and neighbors and Americans just as much as they are.
And there are a lot of misconceptions about what kind of benefits a lot of these people get or take advantage of. And, you know, part of that is because of social media and the misconceptions that are perpetrated over and over again. The American public needs to inform itself. What about the legality of deploying the National Guard in Los Angeles, specifically by President Trump? A very contentious issue.
I think we won't know the answer to this one yet. I think it will take another crisis, another deployment. The reason is because this litigation is effectively frozen. In practice, of course, he has been able to deploy the National Guard in litigation by the governor of California, suggesting that doing so was illegal because it was not done through his office. He lost on one of those preliminary decisions that we talked about earlier, but a final resolution of the case could still come. It's unlikely that it will because this is effectively moot. President Trump is likely to have withdrawn those troops from Los Angeles.
Oh, he just did?
Yeah.
Okay. I think a couple of days ago, yeah.
Then it's unlikely that that case will ever get resolved. So we won't know exactly what the law, we won't have a final determination from the courts here. This is another situation where it would be great if Congress gave it some clarity. This is not the best, the most well-written statute. What does it mean for the president to authorize troops through a governor? Does that mean that the governor needs to give permission or just needs, I don't know. Does it mean he needs to send him a letter also? Congress should clarify that. In my personal view, I think deploying the National Guard in circumstances short of invasion, as is described in the statute, is a remarkable extension of executive authority in the most naked and militaristic and violent fashion. But it's up to Congress to decide what the limits of that are, and their limits aren't that clear, and the courts have struggled with it. The American people are struggling with it. We need more clarity from Congress on this.
Yeah. Rick, did you want to say something?
No, I think one of the things, the question is what precedent does it set? And I think that the legal precedents, as Nathan described, the appellate court, and I think Governor Newsom in California thought that he brought lawsuit here, he thought he was going to win. That did not happen there, but I do think it's going to be moot. But politically, you begin to set the precedent of when do you deploy the National Guard or the military in the domestic context. Clearly, that's against what some of the statutes say. But you did have some circumstances here with the riot, with ICE, with the federal legislation involved. And so I think for now it's going to be moot, but it is another example of pushing that limit pretty far.
Yeah, and I think if we get to that point again, the issue will probably go to the Supreme Court because the core issue revolves around whether the president does have the authority to federalize the National Guard without a governor's consent, and whether the circumstances in Los Angeles met the legal requirements for that kind of federalization. You know, Nathan, I get the impression that you don't think on the surface it does? Not under these kinds of circumstances.
Based on what I know, in my judgment as a citizen, not as a lawyer, but I think that's inappropriate. As a lawyer, I think the statute's quite complex here and deserves some clarity. And this is a good illustration of the limitation of courts here. Courts, as we talked about, resolve disputes between parties, and they do it slowly. That's fine. That's probably good in most circumstances. But if the president can deploy troops in a gray area of the statute for 2 weeks, 3 weeks, 6 weeks, not get an injunction against it because we don't want to prejudge the government's action, but then by the time we actually reach the merits, well, the president has withdrawn the troops. The president can repeatedly do this, and there's some ability of courts to check that, but it's quite difficult. Courts are great at a lot of things, but stopping rapid executive action in gray areas of the law is just not one of them. Other branches, namely Congress, need to do something about that. And the people will have to have something to say about that as well.
You know, Gavin Newsom challenged the deployment, arguing it was illegal and violated the state's authority. I think he's worried that the precedent was dangerous there, and he wants to keep it from becoming precedent.
Yeah. I think that's correct. Like, we have in history a number of similar incidents where a president and a governor disagreed about deploying the National Guard. Some of them we celebrate. The desegregation of schools in Little Rock, Arkansas is one example. So it cannot be right that the president never has the authority to do this. But under what circumstances does he? That's not really something the courts can resolve very well. Congress needs to lay out specific circumstances. They try to do so in one statute. It seems like it's not that clear. It needs some more congressional intervention here. I don't think the courts can solve this particular problem.
How about twisting arms on local jurisdictions and saying, like UNF Campus Police, and saying, we're deputizing you to be immigration enforcement officers. Otherwise, there will be a price to pay.
Yeah.
Is that...
A bugbear of my conservative legal scholar friends for decades has been excessive federal interference in state government in general, and in particular, federal commandeering of state officials, ordering around state officials to do federal policy. They hate that. I think they're right on that in general. But that's exactly what we see here in the context of ICE. Now, some states have willingly gone along with it, but others have not, and nevertheless have been put in positions where, even despite local legislation on sanctuary cities, on refusing to cooperate with ICE, they effectively have to do so in jails, or effectively have to comply with warrants and other things. This federal-state tension is normal, but commandeering of state officials is a problem, no matter who's in the president's office and what the particular policy objectives are.
And you've got state jurisdictions commandeering local jurisdictions. Look what happened with Alligator Alcatraz and Governor DeSantis. You got people in Collier County going, whoa, you know, we find out, you know, through the grapevine that all of a sudden you're taking this sacred native land and you're turning it into a detention center. You know, number one, we believe it's unsafe. Number two, this is our land. What you doing here, Governor DeSantis?
Politically, that's a huge problem. Legally, though, local governments are creatures of state government. They are created by state governments and can be dissolved by state governments. Rick, who knows the story of Jacksonville's consolidation well, can tell you that in detail, how that's only possible with state legislation. The federal Constitution guarantees certain rights and certain duties to the states. The state constitutions may or may not guarantee to local governments. But that's a legalistic answer. The political answer, is this something we are willing to do as a country? Is this something that the residents of Collier County are willing to have in their county? They should have a voice in that. And any responsive state government should listen to those voices. Now, sometimes it will need to determine that the needs of the state outweigh those voices, but just to ignore them or to say that they don't have a voice, while it might be the correct legal answer ultimately, is not really a very good political or social or moral answer.
Yeah, Rick, maybe this is a bad analogy, but it's like we're building this road, your house is there.
I'm not so sure, but I want to go back to the political piece of it because there's a blue-red divide on this, depending on state by state. And you can see this has become a political issue in the New York mayor's race, for example, as to how cooperative they're going to be. And then you come to Florida and the sharp contrast of how cooperative it is in the state of Florida. And that is a blue-red divide. And that plays out in other parts of the country, too.
All right. Let's talk about what's going on. Trump basically enacting an act of retribution, dismantling the Department of Justice, getting rid of the prosecutorial staff. There's virtually no one left there to hold him legally accountable. The Attorney General constantly does his bidding now. I doubt there's any question there. Well, maybe there is. You may disagree with me. Are we in unprecedented territory, and does it allow for rogue actions?
The president views, and he is on record as saying this, he basically views the Department of Justice as his personal law firm. And if there's anyone in the Department of Justice that he views as disloyal or not part of his agenda, he doesn't support them and in many cases has fired them. I think that's utterly corrosive to the rule of law in this country. What should the relationship be between the president and the Department of Justice? It's actually quite difficult. The Attorney General is appointed by the president, confirmed by the Senate, and at least nominally is inferior to the president. But it has been a long tradition, especially since Watergate in this country, that it is inappropriate for the president to interfere in individual investigations. That principle appears to have been completely violated within the last few months. And it is also, there's some measure of independence of individuals in the Department of Justice, political independence, investigatory independence that appears to have been set aside as well. That is utterly corrosive to the rule of law in two respects. One, it means that we don't have a check on the president's powers. We don't have a check on the president's ability to abuse the Department of Justice. And the other is the Department of Justice isn't doing the things that it normally does: prosecuting crimes, investigating crimes, reducing the, even in the area of immigration, which is a president's priority, the Department of Justice plays an important role. And if it's off doing the president's building on whatever his political agenda is, it can't even do that, much less the other things that Americans care about.
Somewhat a matter of degree. This is not new, and this wasn't created by the Trump administration. You go back to John F. Kennedy appointing his brother, Robert F. Kennedy, as Attorney General of the United States. And as Nathan rightfully points out, in Watergate, which was a decade later, you certainly had the post-Watergate era. But you've seen this criticism before. You've seen it during the Bush years. You've seen it during the Obama years with Eric Holder. You saw it with Joe Biden, and you're now seeing it with Donald Trump. I think the argument is a matter of degree, because certainly it is being pushed to an extraordinary extent right now. But there is nothing new at all about the expansion of executive power. That was true during the Biden years, of course. That was true during Barack Obama. It's particularly true with Donald Trump. And this relationship with the Department of Justice. I do think people are very concerned about the matter of degree here and what is going on. But it would be wrong to say that this is being invented right now. This has been a challenge for a long time.
It's just a matter of degree.
Well, let me tell you, it can matter, that degree. That matter. I'm not trying to minimize the matter.
I agree with Rick here. We may disagree about how big the degree is, but he is absolutely correct that historically the relationship between the president and the Department of Justice has been a complex and difficult one, and there are historical examples of abuses that, if you zoom out, look in kind, if not in degree, similar to ones that we're seeing now. I think that's absolutely correct.
Time to take a breath. When Politics and Power continues, little doubt the Supreme Court view is giving President Trump significant leeway, with potentially more to come. The Chief Justice answers critics, but is his answer sufficient? Stay with us. Welcome back to Politics and Power. Bruce Hamilton, along with News4JAX political analyst and head of the Jacksonville University Public Policy Institute, Rick Mullaney, and Jacksonville University law professor Nathan Richardson. So I mentioned the Supreme Court giving the president a lot of latitude. Chief Justice John Roberts answers the critics this way: the idea that we're responsible for whatever somebody is angry about, it just doesn't make any sense. And it's very dangerous. A judge's role, he said, is to interpret the law to the best of our ability, not to write the laws. Liberal members of the Supreme Court are incensed. If you're wondering who may right the wrongs for giving the executive branch too much power as they see it, George Conway III, who, by the way, is married to somebody else very prominent in the past in the executive branch, yes, Kellyanne Conway, a prominent conservative attorney he is, has some thoughts on that. He says, we can't expect the courts to save us, even if every district judge in the country and every appellate court in the country and every justice of the Supreme Court agrees that this administration is violating the law left and right. They can't save us. The people have to save themselves here. How can the people save themselves, Rick?
That's long, but I want to talk about that. But I do want to talk about Justice Roberts' point for just a second, because I think one of the most fundamental misunderstandings we have in our discussions nationally is the role of the court. What is the role of the court? Although their decisions make public policy, they are not policymakers. They are not there to decide what's good or bad, right or wrong. They're an umpire in a baseball game to call balls and strikes. And they're not there for one team or the other. And Justice Roberts is trying to point out, if you have concerns over the direction of the country on policy, don't come to the court for relief. That's not their job. And President Trump himself makes this mistake when he criticizes the court for getting in the way of his agenda, because it is not their job to either further or delay or inhibit his agenda. It's their job to interpret the law and to call balls and strikes, and not to substitute their policy preference for what the legislature has said or what the Constitution says. So George Conway is saying, don't look to the umpire to win the game. Look to the people. And the people, in the end, I remember back in undergraduate school, we were talking about the extent of presidential power. And presidential power, of course, significant in the Constitution and statutes, but in the end, public support, politics, and that support matters a great deal as to what a president can do and what a president cannot do. And the people themselves, if they are, and what they're willing to accept, and what they're willing not to accept, what they're willing to support and what they're not willing to support. That shows up in the ballot box, for example. That shows up with media coverage. That shows up with other checks and balances such as Congress. And by the way, the midterm elections are a year from November, and that will get the attention of Congress. And as Nathan pointed out in the first half of the program, so far at least, with slim Republican majorities in the House and Senate, you haven't seen much of a check. But as you head into those midterms, they may get a little more courageous when some of them want to preserve their seat. So I think Mr. Conway is making the point is that although the court will call balls and strikes and provide some limitations, they're not a policy-making body, and they're not going to save you from where the direction you want the country to head. That requires the people through their elected representatives, the people through voicing, it may be a protest, the people through whatever it is in their activism, but they're constitutionally, those separation of powers and checks, executive, legislative, and judicial, but it all comes back in this country to where the people are. And if the people want to save the country, they need to save it themselves, is what Mr. Conway is saying.
Okay, to use your sports analogy, sometimes when you're not sure about the call, they go back and they revisit what has happened and they look through the prism again because they're not sure if it really was a ball or if it really was a strike. And there are some people who don't think that Justice Roberts is making the right call. They're not sure that he has control of the court, which is the Chief Justice's role.
Well, I thought you were going to, a couple things on that, on those analogies. Sometimes the courts do a replay, and that's when precedent gets overturned. That's what kind of sort of what happened with Dobbs versus Roe versus Wade. You could argue that the court did take a second look. But the other thing I thought you were going to say is baseball analogy, is sometimes you go after the umpire, or sometimes for the ball player there's a brush-off pitch, high fastball in the inside corner that gets him off the plate. And sometimes, I think the president does this, he will send a message to the judiciary and those judges with his conduct and how he wants those opinions to be. I think it's very important, and it's why they have lifetime appointments, for them to be independent, for them to give opinions that they believe in, and for them not to be swayed. Threats, intimidation, support, non-support. And by the way, this happens on the Republican and the Democratic side. You can remember Chuck Schumer outside when he was talking about Justice Kavanaugh in the last term. And so I think the baseball analogy only goes so far. But in the end, I think one of the most fundamental misperceptions is the role of the court. And sometimes, hey, they're not supporting the Trump administration, or hey, they're against the Trump administration. The truth is should be neither. They should be a neutral, nonpartisan interpreter of the law, calling balls and strikes. And for example, birthright citizenship is a good example. That may be good public policy, it may be bad public policy. That's not the issue before the court. The issue before the court is what does the 14th Amendment say and what is the rule of law? And that's why I think Trump has an uphill battle there, and the court isn't going to be determining the wisdom of it, they're going to be determining the legality of it, and they're going to be interpreting the law there.
Okay, so for those who are critical of the Chief Justice and say that they think that politics may infiltrate some of the decisions, you think they're off base?
I think the conservative and the liberal members of the court would tell you that's not their job. I think both of them would tell you that it is their job to call balls and strikes. Now, I do think Justice Roberts cares a great deal about the court itself, the integrity of the court, the reputation of the court, and he does take that very much into account. But on the merits, if the court's operating as it should, should not be about politics, it should not be about policy preferences, it should be about the rule of law.
As a jurist, do you think his legacy will bear that out, Nathan?
I think he'd like it to. I think he's correct in his legal description of what the court's proper role is. I think it's politically naive, however. I think the court has always been, to some extent, it's a political institution. I think it is, and I agree with Rick here, it is at its best when that is minimized or sometimes when it's kept under wraps a bit. When the court picks its spots, it's relatively minimalist. And I think broadly, Chief Justice Roberts seems to agree with that view of the court, broadly, at least in his public statements. The inaction of Congress recently has forced a lot of policymaking to both the executive, and then both parties have figured out, both sides of politics in America have figured out that the only way to stop executive policy is through the courts. So the court has been asked to decide a lot of policy questions. Birthright citizenship is one. Student loans under the last administration is another. That's really an issue that Congress should have resolved through our elected representatives, but it was thrown to the courts. So the courts, I would suspect, Chief Justice Roberts' frustration is forced to be the ultimate arbiter in America of what policy can be. He is also, to some extent, through no fault of his own, I would suggest, somewhat lost control of his own block in the Supreme Court, simply by virtue that it's a 6-3 majority now. It's much easier to control a 5-4 majority. You can change your own vote, as he has done in the past. Now, his vote doesn't matter so much. He has lost control of the center of the court. So those on his side that are ready to go further, that are ready to be a more political institution, to insert themselves more into policy decisions of the day, he can't get them to stop, at least not with his vote.
And he has a couple of loose cannons to deal with, in Alito and
disagree.
Thomas, or Alito's wife. You're not going to comment. Look how the president operates. The legal boundaries exist, but the administration, according to legal analysts, are treated as obstacles and without deference. Courts issue rulings, as we've talked about. Compliance is an issue for the president because the political culture, according to those same analysts, seems to be weakening. Is what we are witnessing in 2025 just the president testing the system?
Perhaps we'll see. The suggestion that he's, on one sense, yes, he's trying to see how much he can get away with vis-a-vis the other institutions of government and ultimately the American people. Testing it implies that there is some point at which that test will be passed or failed at some point. That there will be some point where the courts will say here and no further, and then we'll know whether this is a truly lawless presidency or not. If that's your view, I would encourage you, I would try to dissuade you from it, that there won't be just one test. Partly because that's not the way the president works, and partly that's not the way that courts work. There is not a case, and there will never be a case, that says, is this president obeying the law, period. There will always be some legal argument that the president will latch onto that says, no, what I'm doing is actually fine. And we will just have to see in incremental steps whether the courts allow that or don't, and then how the president reacts to that. The president has already openly defied a number of court decisions. Kilmar-Abrego Garcia case is probably the most well-publicized example of that. But recent evidence in the New York Times suggests that it's fairly widespread. Every president tries to find ways around court decisions he or she doesn't like. So that's not surprising when you look at it, just zoom out in the abstract. But the frequency of it, the rapidity of it, the depth of it, the coming up with pretext, the openly lying to courts, the administration officials saying that profanely that they don't care what the result of a court decision is, and then, by the way, that same government official getting nominated to a federal judgeship. I'm talking about Emil Bove here. That suggests an utter contempt for what the courts have to say. But again, the courts can't save us. There would be no point at which we know, here's the Rubicon, and now we have crossed it. If you're waiting for that, you'll never get there. You're allowing an incremental erosion of the rule of law to happen under your nose if you're just waiting for that.
But if he had his way, he'd like to turn the presidency into a purely political institution without any regard for the courts.
That seems to be the case, although I suspect many presidents would feel that way. Like, President Truman had the sign famously on his death that he says the buck stops here, but he also expressed frustration when Eisenhower, his successor, came into office, and he told him Eisenhower will hate it here because it won't be like the Army. He'll call up people, ask them to do things, and nothing will happen. So every president is frustrated with limitations on his power, whether they be bureaucratic or Congress or the judicial branch. That's normal. But what I think is not normal is the degree of contempt for other institutions that the president has openly shown. But I don't think that will come to a specific head in a way that we'll see, and all Americans will suddenly recognize that this is too far. I don't think that's going to happen.
So Rick, will this president, Donald Trump, act until political resistance becomes strong enough to stop him? Talking about Congress, maybe the midterms.
Yeah, there is no doubt that the president, if you've seen the first 6 months of his life, what he has enjoyed most, of course, is the tariff power, because by executive order, he likes to govern through executive order. The big exception, and he's had some of the least amount of legislation of any president in the first 6 months in the history of the country. In part, despite the majority in Congress, he hasn't gone to Congress a lot.
What's a do-nothing Congress?
Well, And that's what, but his preference for getting things done is to not go through Congress except for the bill, except for the budget, which he had to do, what he calls the big, beautiful bill. There's a lot of pieces to that discussion. I do think that legally sometimes, and through his executive orders, he sometimes does it for a political purpose. And I don't know if he's really concerned in the end whether he wins or loses, as long as he sends that message to his base, such as birthright citizenship. But I do think he's made one pronouncement that I do have, that I'm hopeful is correct, and that is this. When it comes to actually disobeying a Supreme Court decision or a court order, I believe that's the bright line. That's the red line. And I believe that gets you into the territory of constitutional crisis if that were to happen. The president has repeatedly said, unlike some of the people below him sometimes when they're enforcing some things, that he will always follow a court order. And really nothing is more fundamental to the operation of our system of justice and rule of law is the following of court orders. I believe he will. And I believe there are several cases in which he's going to be on the losing end of some of them. I'm not so sure he's that concerned about it because I think bringing those cases, he's made his point politically. But legally, he's going to have an uphill battle in numerous cases. So in the end, I think that's where it's going to end up.
Yeah, and I think you've answered what was going to be my next question. Has there been a real test? And given what you just said, there hasn't been.
I don't think so, but again, I don't think we will necessarily see one. Either things can happen like we talked about in California already, where Trump takes the action, legal proceedings starts, but before it's over, he's effectively done the action, withdrawn the troops, and then it's never resolved. Another possibility is, I hope I'm not putting words in his mouth, but something that Rick seemed to allude to, where he and I both agree that it's likely that this birthright citizenship issue on the interpretation of the 14th Amendment will come before the court. The court will make a decision and it will say, no, if you were born in America, you are an American citizen, subject to some very narrow exceptions. So the president, in a sense, will lose on that. But I suspect, and this is the subtext of what Rick was saying, that the president will probably de-emphasize it at that point, point to other actions he's taking to take a hard line on immigration, and it won't be as politically important. Like, he won't openly defy that. Whereas on smaller issues, like the deportation of a specific individual, Kilmore Abrego Garcia again, but there are other examples of this, he is likely to take a hard line, has already defied some court orders, is likely to continue to do so. But not in this final, okay, it's a constitutional issue with a clear text and this the Supreme Court, and now the president is saying, I don't care anymore. Let them enforce it.
Not where he gets to the point where he's
I don't think he's going to do that. Right. I don't think he's going to do this kind of open contempt. Yet we can still have piece by piece erosion of the rule of law to the point where whatever the courts do ultimately decide is fairly irrelevant to the actual policy that gets implemented.
The president accused the Supreme Court of not allowing me to do what I was elected to do after it temporarily blocked his administration's effort to deport migrants with alleged ties to Venezuelan gangs. Go back to Abrego Garcia. Is he treating the judiciary as just another adversary and ignoring its rulings? And does that risk an even deeper constitutional crisis?
Well, this does go back to something I said earlier in the program, and that is the role of the court and the view of the court. And Donald Trump has made a number of statements when he's disappointed in their rulings that they're not supporting his agenda, which goes to something fundamental. I don't fault the president for wanting to push his agenda. I don't fault him for wanting him to be successful. But the role of the court, they are not an extension of the Trump administration. They are an independent branch of government, and they have a very separate role. And their role is not to support his agenda or to undermine his agenda. Their role, as I said earlier, is to be an umpire to call balls and strikes and the rule of law. And those rules are fundamentally important in the near term and the long term. So Donald Trump, when he's disappointed in a ruling, because he wants one thing, he wants to win. And he wants to be successful on his agenda. And when a court rules against him, he feels that is getting in the way of his victory. Therefore, there's something wrong with them. They're not supporting me. But it's not a question of support. That's not their job. For this system to work right, it needs to be the job we've talked about throughout this program. And that's why this third branch of government in Article 3 is so important. But remember, as a former president once said, let them enforce it. We were talking about that. Let them go enforce their rule. I don't think we're there. I think in the end, despite all the bluster, if it's, as Nathan mentioned earlier, in a Supreme Court decision in which there's a clear ruling, I don't think the president's I'm not going to follow that. That's a real constitutional crisis. So in the end, I understand the president gets disappointed if he's on the other end of a ruling, but it's not because the court is trying to upset the Trump agenda. It's that they're not a part of the Trump administration. They're in the judicial branch of government, and they have a fundamentally different role to play.
And that's because, as we started off saying, his focus is on is on politics, and it becomes a question of how far can he go, whether or not anybody can stop him. And I don't think he's faced the real test on that yet either.
No, not politically. Like in America, we have limited ways to influence the government. One is elections. An election just happened. It's going to be a year and a half before the next one. Now, there are, of course, local elections, state elections, special elections, and those can have a political influence as well. Folks and members of Congress can read the writing on the wall when they see a district flip or something. So voting still matters, even in this interstitial time. Courts matter in the meantime, but other ways that people can influence politics, can participate in their community, join protests when they think that's appropriate. It's going to take politics does. Look, Americans are busy. They are trying to put food on the table. They're trying to solve the problems of their family. I got kids at home too. Like, politics can't dominate all of your life. But it can't also be the case that like politics is just something that happens at elections and then you like check out in between. That is like both joyfully and sadly, that is our responsibility as citizens in a republic, that like we have to continue to participate in the ways that we can, that we're able to when we see an opportunity to do so. Otherwise, there will be no check on any executive, whether it's Trump or any other president.
And the reality is the American public isn't necessarily clued in to what really is going on politically. All you have to do is talk to them. All you have to do is look to where they get their news these days. All you have to do is listen to what they believe is real news. If you look at the surveys about the big, beautiful bill, most of them had no clue what was in it.
That might be also true if you surveyed the members of Congress, frankly.
Yeah, most of them had not read the 968 pages or whatever it is. And now they're backtracking. They're going, I didn't know that was in there, or maybe I wouldn't have voted against it, or the only reason I voted for it was because, I was worried about getting reelected. Gentlemen, up against the clock here, final words?
Just to reiterate what I just said, that like it is the responsibility of citizens to participate in democracy. Courts will not save us. Elections are vital and important, but they are not the only means to participate in politics. If what the government is doing, whoever's in the presidency, whoever's in Congress, whoever's in the governorship of your state, you think is something that's outrageous and can't be accepted, then it's your responsibility to work in your community to do something about that. Don't count on the courts to save you. It is the responsibility of citizens of a republic to keep it.
Two brief points. One is, and we've talked about it a great deal, the role of the courts is fundamentally important, obviously, to the operation of this government. And an understanding of the role of the court and the role of the Supreme Court is really important. And I think it's so often misconstrued that they are simply political in the sense of a policy agenda. So important that the courts remain independent, so important that they call balls and strikes, so important that they have the role they have. Separate from that, on the policymaking side, a year from November, about a year and a half away, is the midterm elections, and that is going to be a really important part of what happens for the last 2 years of the Trump administration. I think the president has till maybe next spring when it comes to tariffs and a lot of policy issues and some other things before that gets somewhat solidified, and history will not be on his side a year from November because typically the incumbent has a challenge, particularly in the House of Representatives. So politics matter, policy matters, but this all comes together beautifully. As Winston Churchill once said about the worst form of government in the history of mankind, except for all the rest. And I think for nearly 250 years, it has been remarkable. But as this conversation demonstrates, it can be messy, it can be difficult, it can be contentious, but it has worked remarkably for 2.5 decades. But one of the most important things is for us to understand how it's structured. Let the courts be the courts and let Congress be Congress. And the president certainly wants to be president, although he's pushing those limits.
If there is a takeaway from this show, it is that, number one, you have to be an educated electorate. You have to come to your own conclusions. You have to seek out the truth. The show is called Politics and Power, and you have the power. Thank you for watching.
See why every day more people are choosing News4JAX, Northeast Florida and South Georgia's #1 source for local news.